As we are in different time zones. Good morning, good afternoon, and good evening. I would like to warmly welcome everyone to today's webinar on arrest warrants issued by the International Criminal Court. I would like to extend a particularly warm welcome to Judge Sergio Ugalde, President of the Pretrial Division of the ICC, who is our special guest. For those joining us for the first time today, my name is Ewa Hofmańska and I'm leading Project Sunflowers. Today's webinar is the third meeting of its kind, bringing together experts in international criminal law, academics and practitioners, activists, and those who are simply interested in this field. Organized by Project Sunflowers together with the Krakow Center for the International Criminal Justice at the Jagiellonian University in Poland. Recordings of previous webinars can be found on the websites of Project Sunflowers as well as of the Krakow Center. Today's meeting is an open webinar and the recording will be posted on the websites of both organizers soon. We are pleased to note that the growing interest in our webinars. It's a great joy for us, the organizers, that the topics we cover are interesting and timely. It's also a signal to us that there is a need for this type of expert meetings with prominent experts. Thank you for your trust. And now, without further delay, I would like to give the floor to Professor Piotr Hofmański, head of the Krakow Center for International Criminal Justice. Piotr, the floor is yours.
Thank you, Ewa. Thank you. Good afternoon. I just welcome all the participants warmly. I'm especially happy that we have the special guest, my friend Sergio Ugalde, who is currently the president of the Pretrial Division of the International Criminal Court. Well, before I will give the floor to our special guest outside, that is really the great opportunity for all of us to witness the presentation of the person who is, I think, the best possible to inform us about the practical aspects of arrest warrants. Because Judge Ugalde is not only the expert in international criminal law and international criminal justice, but is also the president of the division where all the arrest warrants are issued. So 2 words about our guest. As I said, Judge Ugalde, the president of the Pretrial Division of the ICC, was also a professor of international law at the University for Peace in Costa Rica. It was the post mandated by the United Nations. Was a member of the Permanent Court of Arbitration. Is also the former co-counsel, advisor, and advocate for Costa Rica before the International Court of Justice. And Judge Ugalde is also the political experience because he is the former ambassador of Costa Rica to the Kingdom of Netherlands, and it's a representative to OPCW and the Hague Conference of Private International Law. And what's also important, very relevant, he also served as a vice president of the Assembly of State Parties to the Rome Statute in 2016-2019. 2018. So this is the person who had the opportunity to just to witness the process for both sides, yeah, for the judicial side and for the side of states who are crucial in the process of enforcement of arrest warrants. Sergio, thank you very much, very warmly for your time and for being with us today. My other friend, Professor Paweł Wiliński, who is the judge of the Polish Supreme Court, is also expert in international criminal law, and what is also important in the context of this webinar is the president of the Council of the Foundation Sunflowers, kindly agreed to moderate the discussion. I asked him, not only because he's expertise, but also because I couldn't do it, because I would like to be active participant of the discussion. So, Paweł, thank you very much for agreeing for being with us today evening. And I will give you the floor. I understand you will also moderate the discussion after the presentation of our special guest. Thank you very much once again to everybody, and I hope to be a part of the discussion after the presentation. Thank you, Paweł.
Yes.
To you.
Yes. After these great interventions and short presentations, we will go straightly to the main point of the meeting. We are very happy to have here President Sergio Ugalde. Thank you for accepting invitation. We can promise you that Professor Hofmański will have difficult questions for you. We expect more from the audience, but this will be after. So the program for the meeting is as follows. We will have the presentation from Professor and President Ugalde, which shall last, as we know, about 30 minutes. And then there is a Q&A time. Everyone is invited to ask questions, and we will have a discussion for about 1 hour. I will just try to moderate the discussion and to close the discussion in time. That's what I was obliged to do. Okay, President Ugalde, thank you again, and please, we are waiting for your presentation.
Thank you very much for the kind invitation to participate in this forum. Of course, I'm very pleased to meet former president of the ICC, Piotr Hofmański, a person who has a significant legacy in this court, in general, in the field of international criminal justice. And of course, when he invited me to participate in this discussion, I'm more than pleased to do so, especially also given the significant amount of participation that we can see. I just want to start. Unfortunately, I have to make a disclaimer in the sense that as I am an acting judge in a number of situations, I will not be able to refer specifically to any of the situations in which I am making decisions currently. But of course, I will give an overall explanation of how the pretrial division works, and fundamentally about the warrants of arrest. So let me start by explaining what probably most of the audience knows already, that the International Criminal Court
excuse me, Ernest Ambeche, please, if you could turn off your microphone. We are disturbing. Sorry, can I ask administrators of the meeting? Oh, yes.
Okay.
No, disclaim this participant. Ernest Ambe, I believe, is using his microphone. Sorry, President.
That's okay. It happens. I know.
Yeah.
That happens. Well, I'll try to continue, and let's hope that the mics can be turned off. So at any rate, as I was saying, the International Criminal Court, what is called the judiciary, is made of 3 divisions. So the pretrial division, where I am sitting, the trial division, and the appeals division, where Judge Hovmansky served his term. So fundamentally, the pretrial division is charged with, or by the statute, to carry out a number of activities or decisions at the outset of cases. So most of these decisions are set out in Article 57 of the Rome Statute. So among some of the decisions that are or that the pretrial division needs to address are the authorization to the prosecution to open a proprio motu investigation, pursuant to Article 15 of the statute, a preliminary rulings on admissibility, pursuant to Article 18 of the statute, decisions on challenges to the jurisdiction of the court or the admissibility of a case according to Article 19 of the statute. Also, the decision to authorize the prosecution to investigate within the territory of a state party without having to secure the cooperation of that state under Article 54 and 57 of the statute. The decision on the confirmation of charges are according to Article 61 of the statute, and decisions on the protection of national security information on Article 72 of the statute. I will explain a little bit more or less how a case may be brought by the prosecution. Generally, the prosecutor may bring or start a case before the court by launching what is called an investigation. Now, an investigation can be done proprio motu, in the sense that it is the prosecution himself, the prosecutor, who makes that decision. But for the investigation to commence, the pretrial chamber or a pretrial chamber, in case of a situation, must give him the authorization. The other way in which an investigation may commence is by the referral of the state concerned. So a state may decide that it wants the court to investigate a situation in which potential international crimes may have been committed in that state. And we have a number of countries who have referred cases before the International Criminal Court, such as the Central African Republic, where I currently also sit in one of the trials. The cases may also be referred by a group of states parties to the Rome Statute, may refer another state in circumstances where those states believe that international crimes may have been committed in the territory of that state, and also by a decision of the Security Council. So currently, the ICC has 2 cases where it is dealing with referrals of the Security Council. One is the referral of the Libya situation, and the other one is the referral of Sudan's Darfur situation. And as a matter of fact, yesterday, one of the trial chambers issued judgment on one of the persons accused of having committed crimes in Sudan, Darfur. So this is generally how a case begins. Now, for the cases where referrals are made, the pretrial chambers don't need to give authorization to the prosecutor. The prosecutor may commence that case immediately. It's only when the decision of the prosecutor to initiate a case that he needs to seek the authorization of the pretrial chamber. Now, once a prosecutor had begun the investigation in a situation state, and where that investigation leads to him to believe that international crimes may have been committed in that territory, And let's remind ourselves that those are crimes against humanity, war crimes, the crime of genocide, and also the crime of aggression, which jurisdiction of the court was activated in 2017 for those states who accept the jurisdiction over that crime. Once the prosecutor decides that an international crime may have been committed in a given state, then of course he investigates the persons who allegedly may have been party to those crimes, who have been actively participating in those crimes, either as direct perpetrators or indirect perpetrators, or assisting in the commission of the crimes. If that's the case, then the prosecutor reaches out to the pretrial chamber in charge of that given situation, and the pretrial, in order to request either one of two, how can I put it, requests. So one of the requests could be for a warrant of arrest of an individual. In the other request he can put before the pretrial is what is called a summons to appear. And I will explain in turn what that means specifically. Now, concerning the legal basis for a warrant of arrest, that is the Article 58 of the Rome Statute. The nature of the proceeding is ex parte, meaning that it's only the prosecutor who at that point in the proceedings makes the request, and no one else is participating in that aspect of the proceeding. So the prosecution provides the request along evidence that the person may have committed the crime. The person charged by the prosecution may have committed the crime. The conditions for issuing the warrant of arrest, according to the applicable law, is what is called the standard of proof, and that is that the pretrial chamber must be satisfied that there are reasonable grounds to believe that a person has committed crimes within the jurisdiction of the court. Now, reasonable grounds to believe is a relatively low standard of proof, lower than what is called substantial grounds to believe, which is applicable in what is called the confirmation of charges, and of course, which is also lower condition or standard than what is called beyond reasonable grounds, which you apply only when you are at trial and you have to make a decision of conviction under Article 74 of the statute. Now, what is this so-called reasonable grounds to believe? I mean, how do we understand what it is? How do you reach that conclusion? So the reasonable grounds to believe means that it is one, but not the only reasonable conclusion that a person committed a crime within the jurisdiction of the court. That means that the pretrial chamber does not need to have certainty that the person has committed the crime, but has to have a reasonable suspicion that the person may have participated or committed the crime as charged by the prosecution. Obviously, this means that the person who is allegedly having participated in the commission of the crime doesn't mean that it does not have rights or that it is already reputed to have been committed the crime. That's not the case. The fact of the matter is that that person is not yet convicted, and that person still is afforded a significant number of defenses at the different stages of the proceedings that he or she may face as the trial goes along, or as the proceedings before the court goes along. Now, why is it important to have a warrant of arrest issued? So the arrest of the person appears necessary, and the reason for that is, first, to ensure the person's appearance at trial, and to ensure that the person does not obstruct or endanger the investigation or the court proceedings, or to prevent the person from continuing with the commission of that crime or a related crime which arises out of the same circumstances. So if these conditions are met, the pretrial chamber is bound by the statute to issue the warrant of arrest. In other words, the decision to issue an arrest warrant is not discretionary. It needs to fulfill this criteria. As the case is, warrants of arrest in a significant number of cases are issued what is called either under seal or secret. That means that they are not public. They are not known to the wider public. And the reason for that, of course, is that if there are what is called opportunities to arrest and surrender the individual, obviously you don't make it public as such. But you do have to communicate if an opportunity to arrest arises. You need to communicate to the state where the person may be at that time, the warrant, in order for the concerned state to assist the court in the arresting of the person and then surrendering that person to the ICC. So, for example, I think in the month of July or so, there was an individual sought by the International Criminal Court in the Libya situation. This person was arrested in Germany upon a warrant of arrest served by the ICC. That person has not yet been surrendered to the ICC because the person is undergoing judicial review in the state where he was arrested. So in this case, it doesn't mean that once a person is arrested, that person is automatically surrendered to the ICC. That person may be subject to an internal or domestic procedure in order to make sure that the person's rights have been respected in the process of his arrest upon the serving of the ICC warrant. So in the case of this individual who has been arrested and remains in Germany, that person has reached out to German courts in order to seek his rights or defend his rights as he sees them, and that is an ongoing process. Now, the German courts may decide that there are issues concerning the fairness that of the manner in which he may have been arrested, that there might be remedies that need to be allowed for him to take advantage of, or may decide that the proceedings have been lawfully carried out by Germany, and therefore that the person can be surrendered to the ICC. That is generally how it happens. Once the person is surrendered to the ICC, then this person will undergo very shortly after the person is surrendered, within, say, 48 hours, 72 hours, what is called the first appearance. And the first appearance means that the pretrial chamber, which issued the warrant of arrest, reads out to him or to her the charges of what he is being charged of by the prosecution. Of course, it's just simply a very initial phase in which the person is formally informed or is aware of what he's being charged of. Thereafter, there is a proceeding, what is called confirmation of charges. And the confirmation of charges means that the basis over which the prosecution has sought the arrest of the person, and then the person to be committed to trial are challenged before the pretrial chamber. And that means that this is a separate analysis that the pretrial chamber will have to make, in the sense that then the prosecution needs to fully inform the pretrial chamber of all of the charges and all of the evidence, or at least the most significant evidence, that the person who is being charged may have committed the charges, and that therefore that person can be committed to trial. This process generally takes about 6 to 8 months, in which, of course, the person will be afforded a defense. The defense may challenge the charges as such, and then there will be what is called a confirmation of charges hearing, where the parties will discuss the legal basis of the charges, both in terms of the applicable law, but also in terms of the value of the evidence that is being submitted. So what the pretrial chamber does at this point is simply to determine whether there are reasonable grounds substantial grounds to believe that the person may have committed the crimes. So that means for this confirmation of charges to be carried out by the pretrial chamber in charge of the confirmation, the charge, basically the definition or the criteria is that the charges must be sufficiently compelling, going beyond mere theory or suspicion. Means that there are grounded reasons to believe that the person have participated in the commission of those crimes. It doesn't mean that the person is that the pretrial chamber is prejudging the guilt or not of the person. Fundamentally, the pretrial chamber makes sure that the case of the prosecutor against the individual is sufficiently strong to be tested at trial. And that is fundamentally what the pretrial division, the pretrial chamber does at that stage of the proceedings. If the legal criteria is met, then the person will proceed to trial, and that will go, then leaves the pretrial division and goes to the trial division, where a chamber will be put together by the presidency of the court, as my friend Piotr Homansky did many times, including with myself, where he assigned me to a trial division case in one of the Central African Republic cases. So that is fundamentally how that works in terms of the arrest warrant and what happens when a person is detained, surrendered to the court, and thereafter is read the charges, and then proceeds to the confirmation of those charges. Now, I'm briefly going to refer to the possibility that a person has not been arrested or is not given summons to appear, and but there is an ongoing case before the ICC, and in which case that person could be or the confirmation of the charges against that person may go ahead in absentia. And that is the case, for example, of Joseph Kony, a person who has been alleged to have committed very serious crimes in the territory of Uganda and in other countries in that region, very, very serious crimes against civilian population. And therefore, that person is not being able to be located. And under the Rome Statute, you could make a confirmation of charges in absentia in those type of circumstances. That is exactly what is happening, where there is a pretrial chamber dealing with the confirmation in absentia of that case, and which is undergoing, and there will be a decision made possibly sometime now in November. Now, in relation to a summons to appear, the summons to appear is means, of course, that the person is not requested to be arrested as such. Simply what is required is that the person or the chamber is convinced that the person would be available, and therefore, or that there are guarantees that the person will be available to surrender himself or herself first to the confirmation of charges, and if the confirmation of charges goes ahead in the sense that it is agreed that the charges are confirmed, that that person will also appear before the given trial chamber that may be composed to go on with the trial. This kind of summons to appear did happen in the Kenyatta and Ruto cases, where they were not required to be arrested and surrendered before the court. And they were represented before the court because it was believed by the court that they will face the proceedings before the ICC voluntarily, and they will not escape justice. Ultimately, that their cases did not move the pretrial stage, and the prosecution terminated effectively those cases. So fundamentally, I know that there may be questions that some of you may have, so I'm going to stop here. I'm just going to mention briefly about the fact that the decision to issue a warrant of arrest or a summons to appear, in principle, is not appealable. But there is just a very recent case law where a jurisdiction over the issuance of a warrant of arrest was challenged directly through appeals. There was not a request to leave from the chamber that issued the arrest warrant, and the appeals chamber had decided actually on the jurisdictional challenge, but at the same time decided on the actual issuance of the arrest warrant, and had made a decision to that effect. So we are still trying to figure out what is whether this creates a precedent in the sense that warrants of arrest can be appealed or not. But this is very, very new, and I just wanted to bring this out. So I'm going to stop here. Any other questions that you may have in terms of the functioning of the pretrial division, I'll be happy to comment about that. But I know that people may have questions, and so I will stop here, and I ask Professor Filinsky to carry on with his duties, moderating the discussion. Thank you.
Thank you, Mr. President. That is a first-hand information. That is a strong information and a privilege for all of us that we could hear this information and let's start the discussion about the arrest warrant. This is a controversial institution, that's for sure. And probably I would raise just one sentence among many presented by President Ugalde. He said, the situation is interesting when a person has not been arrested. The most controversial situations probably are related to those who haven't been arrested yet. And the list of those famous not arrested yet, in this case of the ICC, is much longer. I will point just 6 names. Vladimir Putin, President of the Russian Federation, Lvova Belova, Ombudsman from Russia, Hamas leaders, Yahya Sinwar and Saif Mohammed, Benjamin Netanyahu, Prime Minister from Israel, Yoav Gallant, Ministry of Defense. That shows us how strong is the instrument that touch people like this and touch them with accusations so strong to issue an arrest warrant. We will start the discussion now, but before I would like to welcome all the audience, noticing that we also have distinguished judges, the ex-judges of the ICC, Judge Peter Kovac, I saw also Judge Ekaterina Trendafilova, so we welcome all distinguished guest judges, I see prosecutors, the academics, students. You are all invited to the discussion. We just try to keep the discussion asking questions one by one, giving a chance to President Ugalde answer these questions. Keep your questions short and please do not make statements, but just keep them as the voice in the discussion. And then I will ask participants to take the floor. We'll start with Maria Prado.
Thank you. President Ugalde, you mentioned that the pre-trial chamber can take remedies. And I would like to know, in a situation where the defense argues that the accused's right to a fair trial has been violated, but the prosecution maintains that it was merely an irregularity, what remedies could the pre-trial chamber consider beyond the exclusion of evidence?
President Ugalde, microphone, please. We can't hear you.
I'm sorry, I could not really hear Maria. I don't know if she could repeat the question again.
Neither we. Can you repeat the question, please? Sorry, I think we've lost the... Maria, can you ask the question again, the quality of your...
Yes, I don't know if you can hear me better, but the President Ugalde, you mentioned that the pre-trial chamber can take remedies, and I would like to know, in a situation where the defense argues that the accused's right to a fair trial has been violated, but the prosecution argues that it was merely an irregularity, what remedies could the pre-trial chamber consider beyond exclusion of evidence?
Well, I mean, I don't know if I got your question correct, but clearly the whole point of the fact that you have a judicial review of the warrant of arrest, or eventually if a person is being arrested and surrendered to the court, is to guarantee fair trial rights to the individual. So it's not that we automatically agree or rubber stamp what the prosecution is telling us. Our standard is high. So, and also, and I want also to dispel this view somehow that we are a political institution, that we are against people just because we want to be against people or because there are judicial activism. No, we take very, very seriously our judicial duties. And so we make sure that, first of all, the evidence before the court is strong, that that there is a how can I put it, a probable case to be submitted to trial, and where we see that the case is not strong, or that there's have been gross violations of the fair trial rights of the individual, we will decide that. For example, there's a case in which I participated. I will not disclose, let's say, the deliberations that we were having, but the prosecution decided, as we were very near deciding whether we were going to confirm the case or not against this individual, to withdraw the charges of the individual, and we let him go, because clearly, if the case was weak and the prosecution decided that their case was weak, and therefore the possibilities or the probabilities that the confirmation could go ahead were not there, then they have the obligation to request us to or to terminate the case, in which case we had to immediately free him. And I don't know, Judge Homansky, if this happens when you were president. I think you were. But the fact of the matter is, we had to let him free. We could not keep him in detention. We free him pretty much within 24 hours of the prosecution deciding that they were withdrawing the charges against this person. So that's how we act. We will act only on the strength of the cases, and if we see gross violations of those rights, we will make the determinations, whatever these are. And there have been very important cases in which trial chambers have found, for example, that there was not a strong case enough, and the charges were thrown out, and the people were freed without even coming up to a judgment. So that shows that we will stand by the fair trial rights of accused individuals. Pavel, back to you.
Yes, thank you. We have several questions already. We'll start first with hands raised up. The next one is Zuzanna Bartnicka.
Hi, thank you. So I have a question for President Sergio Ugalde. I would really like to ask you if you could elaborate more on the criteria to issue the arrest warrants. What were those? Because I didn't quite catch the third one. I heard that one of those were to prevent the person to continue the crimes and to ensure the person is the right person who committed the crime, but I didn't quite catch the third one. So I would be grateful if you could answer my question.
Yeah, fundamentally, the third one is to prevent the person from carrying on committing the crimes, or the possibility that by having the person freed, there could be ongoing activity that will result in further crimes being committed. So we have done that. As a matter of fact, this is something I did not explain, but this is connected. While we could issue the warrants of arrest secret or under seal, that means that only very few people within the court knows the existence of the warrant of arrest, and we will only notify a state about the existence of the warrant and request that state to arrest when we know that the person is in that state, and that the state is going to be able to cooperate with the court in the arresting and surrendering of that person. There are warrants of arrest that are publicly known, the content of the warrant itself and the existence. And we have recently had the practice of doing what is called making known the existence of the warrant but not disclosing the information of the warrant itself, not the substance. And the reason why we have done that is because we find that it is in the interest of justice for the wider public, the international community, to know that the warrant exists against that person, but we want to protect the investigations ongoing, so that's why the substance remains secret, and also to protect witnesses. And that's why we keep those warrants secret. I just wanted to make that point. Thank you.
Thank you.
Thank you very much. And thank you for switching on the camera, Susanna. And this is also the request to others asking questions, taking part in discussion. If it is possible, please switch on the cameras. We do not think that this is GPT discussing with us, but it's always easier to see living people. So the next question comes from Abdirahman Elmi. Abdirahman? If not, the next question comes from the person that I can see, which is Piotr Hofmanski. Piotr?
Yeah. Thank you. First of all, thank you, President Ugalde, for this presentation. So I think that after this presentation, we know very exactly how it works, but we don't know why it doesn't. And this is my problem. And a question in a minute, but you know, there are cases, there are situations, there is no slightest chance to get the person arrested because of the lack of cooperation, especially if it does concern the non-state parties to the Rome Statute. The chance for cooperation is close to zero. It leads to complications because the Rome Statute does not provide enforcement mechanism. The ICC has to rely on the cooperation of states, especially in respect to the arrest warrant, but of course also in other areas. In that respect, I have the basic question that you probably partly answered already, but I would like us to point it very clearly. Where do you see the arguments for issuing arrest warrants knowing that there is no chance for the arrest warrant to be executed? This is, I think, the question he is asked for many external observers. And the second, if you allowed me, I have also the second question, just to avoid taking the floor too many times during the discussion. The second question concerns the practice of the publication of the request for arrest warrant. So the ICC has no common practice. In the beginning, the ICC, the prosecutor, announced requests for arrest warrants before the arrest warrants were actually issued. Regardless of whether it's appropriate or not, I would like to ask you, what is the current practice of the court? I think it's really important that the information, if this share with the external world, should go from judges and not from the prosecutor, simply because it's not always the case that all the requests will be accepted by the court. And I cannot imagine what would happen if the prosecutor would request the arrest warrant and judges will refuse to issue the arrest warrant, especially in the situation being really politically sensitive. So these two questions I would like to put, and well, Pavel, to you.
No, these questions come to President Ugalde, but this is how I promised. Professor Hofmanski, now having a chance to be more critic, ask difficult questions.
Well, thank you very much, Piotr, for your questions. Let me refer to the first one. You are asking, the first question is, why are we issuing warrants of arrest of individuals that have nearly zero chance of being arrested. First of all, because that's what the law says. The law does not say that we cannot issue a warrant. We cannot issue warrants of arrest if there is no prospect of arresting an individual. That's not what the law says, first of all. And second of all, because we rely on the cooperation of the states parties. So we do our duty according to the statute, and the statute is this international legal instrument approved by an international conferences back in 1998, and is a significant development in international criminal justice, and therefore we follow the statute, and therefore where the law says that or describes what a crime is, and we have evidence that that crime may have been committed, and the law requests the judge to make a determination as to whether the surrendering of that person before the court for it to face a trial is necessary, or the other conditions are met. For example, that the person does not interfere with the investigation or with the witnesses, or that crimes may be stopped, then we have to act on those bases. Once we issue the warrant, and this is not something that we take lightly. We don't take lightly having to issue warrants for individuals. This is a very serious issue. And of course, we are aware of the gravity of the decision, and the importance of the decision that we make. But at the end of the day, that's what our duty is, and we carry on with it. So it is then to the states parties, and that's why there is a significant part of the statute dedicated to cooperation with the states, because we understand, and the states understood when they drafted the Rome Statute, that it was their commitment to cooperate with the court what will make the court successful or not. And therefore, it is their responsibility to carry on assisting the court when we ask them to do so. We know that many states don't, but some states do. And you never know. You can never say that it's 100% certainty that a person will never be surrendered. We just don't know that. And I could point out to at least one case where that didn't happen, and therefore you never know. So the fact of the matter is that I don't think this is a criteria as such. We just see the evidence before us, and we apply that evidence, and we will carry on with our duties in that sense. Now, your second question, if I recall correctly, concerned the practice of the prosecutor to announce publicly the request of arrest warrants before it was communicated to the judges. Well, I can tell you that is not happening anymore, because there has been a number of judicial decisions made by the two pretrial chambers in charge of all of the situations where we have asked the prosecutor, or we have instructed him, better said, not to disclose requests before chambers for warrants of arrest, especially because this causes two problems. First of all, if he or the chamber decides that the warrant is going to be filed secret, then making it public defeats the whole purpose of filing or having to have the arrest warrant registered as secret or under seal, for example. And second, because it also put undue pressure on the judges, because once you announce that you have requested an arrest warrant, then there is a pressure on the judges in terms of the timing and the analysis of the evidence, and therefore we found that this is not a correct manner in which we could carry out our duties in these circumstances. So that's the answer to you. I hope that answers your questions.
Thank you very much. And the next question comes from Mr. Mohamed Zadrash. We still cannot hear you.
Voice?
Yes, yes.
Thank you very much. I appreciate the judge's explanation on the process. I have two quick questions. First one, if the issuance of the warrant has been secretly processed, but the suspect, or we can say that, does not appear in the court, what will be the procedure? Do we have abstentia of the like a trial, do we have abstentia trial processing, or it will stop? That's my first question. Second one, if we issue issuance of the warrant to specific criminal, for example, but he will not surrender, he will not cooperate with the court, so what are the others process that the court would follow if the court does not have the available mechanism to enforce it? Then do the court, it will move to the confirmation of the charges, then it will go to the trial or not? So my question was about 2 points. First point, if he does not surrender, what will be the legal consequence after that? That's first one. Second question is, if the issuance of the warrant has been issued for that specific person, but that person does not surrender himself to the court, then what will be the court will do for enforcing him, and what will be the other legal mechanism that the court will have? Thank you very much for your answer.
Thank you for your question. I mean, fundamentally, I think they are interconnected, your two questions, because fundamentally the criteria is this: if a person is if the person is known, and where the person is, and the person is aware of the existence of a warrant against him, and he decides not to surrender himself before the court, of course, if it is a summons to appear, then the pretrial chamber may change this into an arrest warrant, in the sense that the person or the state, if it is a state party where the person is asked to surrender, to arrest and surrender that person before the court. If the person is in a jurisdiction where they will not act upon a request from the court, which is the case because there may be non-state parties and they will have no obligation to arrest and surrender individuals, unless this arrest and surrender request come from a case that had been referred by the UN Security Council, but that's the only circumstance. But if it is not in that circumstance, so there is no an obligation for a non-state party to surrender the person. Now, in that circumstance, we are unable. The statute is, in that sense, is not very, how can I put it, is not very meticulous, so to speak, and we cannot act. We have to wait until the person either surrenders himself or is in a jurisdiction that can arrest him, and then surrender that or her to us. Now, in a circumstance that is exceptional, in which an individual cannot be located, we don't know where he is, he's been running around, the court does not know. We have made efforts to locate the person, but we have not been able to locate him. Only then, and only then, in those circumstances, can the court, and this is the pretrial chamber in charge, may decide on the conditions of the case to carry out the proceedings of confirmation in absentia. this has been very highly criticized because the problem with the proceedings in absentia is fundamentally that you can potentially confirm the charges against this person, but you cannot proceed to trial because you can only confirm the charges, have that proceeding ready in case the person eventually appears, and then you send him directly to trial. But if you never apprehend him, then that's it. It dies there. Now you question, many people has question, well, why do you have that? Well, it's hard to explain. We have it. But we have found that it fulfills a different purpose because also not only may expedite eventually the proceedings at the trial stage, so going directly to trial, but also because it gives an opportunity to victims to at least be heard at this stage of the proceedings, at least to make representations, and for victims that may be important to know about the truth about what happened to them, and they don't get full redress, but at least they have that opportunity, so they are not forgotten. And we find that this instrument at least allows for that. Other than that, I cannot explain further why we have this strange mechanism. That's what the States Parties created back in 1998. I hope this responds your questions.
Thank you, Mr. President. And the next question comes from Madam President Ekaterina Trendafilova. We're very happy to have you here. And please, you can ask difficult questions to our distinguished guest.
Well, thank you very much, Professor Paweł Wilinski. I'm not here to ask difficult questions. I'm very happy to be here amongst colleagues and people who are very much interested in international criminal justice. I want to commend Professor Piotr Hofmanski, former president of the ICC. By the way, he joined the Constitutional Chamber of the Consul Specialist Chambers, where I serve now as president, and we are very happy to have him on board. So I want to commend him and everyone from the Center for East European Center for International Criminal Justice that filled the lacuna. And as I see, it is so robustly doing a very, very pioneer job, organizing seminars, inviting colleagues to speak, inviting people to ask their questions. And I want to wish all the best for this endeavor. Of course, very happy to see Judge Kovac. I haven't had the happiness to work with you, President of the Pretrial Division, Judge Ugalde. Till 2015, I was president of the Pretrial Division, so I know the difficulties that you experience, but that is what makes our job very interesting, challenging, but we just cannot live our life professional without really facing and resolving challenges. I very much appreciate not only the initiative, but you found sufficient time to respond positively, to come, to talk, to try to respond to difficult questions. Of course, I'm a little bit tempted just to mention that the doubts that my dearest colleague, Judge Hofmanski, has raised about whether it's worth to start investigation, prosecution, thereafter to press charges when the prognosis to have someone arrested and brought before the court is limited at this point in time to zero. No one knows what the future is going to bring. But this question was addressed to one of our colleagues now at the Consul Specialist Chambers, a prominent academic as well. And he asked the contra question, saying, is it better that as if the International Criminal Court pretends as if nothing is happening, that we do not see the hideous crimes that are committed unfortunately, on our planet. And if there would be an arrest warrant, indeed, it is not going to be enforced at this point in time. However, the moral reproach shouldn't be underestimated, because we see that some of those who have been sanctioned, so to say, against whom arrest warrants have been issued, became very careful where they go, where their planes flight, and so on and so forth. For example, Mr. Coney, that my chamber has been dealing with, he has been very, very carefully following very carefully an idea back then to have confirmation absentia. So he found his sources, he was following all the decisions that were coming. So I would still support that the prosecutor, if there is sufficient evidence, and as the president said, the victims are also given a kind of a moral satisfaction that someone pays care about the sufferings that they have been going through, and that they can tell their story, at least during the investigation. What I want to ask you, dear colleague, President Ugalde, something that is not so much related to the legal framework and to the practices of the court that we all follow. What is the spirit amongst the judges with all these sanctions, with this extremely aggressive, inappropriate, even everyday language that is spelled out against the court? I hope that, of course, it's not something that is nice to be faced by anyone. Back then, when I was involved in some cases, also I was facing very, very serious scenarios, 3 levels of undertakings in order to stop the chamber that I was presiding over. But there is a saying in my country: those who are afraid of bears, they shouldn't go into the woods. So I hope that despite of the real concerns, of the immense discomfort and totally undeserved reproach to judges, to legal support staff, that judges are not going to lose their commitment and willingness to make their humble contribution to the field of international criminal justice. To the extent possible, dear President, if you could tell me, and of course I'm waiting your answer with a very, very worried heart, but with the hope that judges are not going to lose their faith in justice and commitment thereto.
Well, thank you very much, Judge Filova, for your comments and your words of support to colleagues here at the ICC. What can I tell you? It's very challenging. I mean, the other day we were discussing that never in the history of international tribunals have we seen the level of aggressiveness against a justice institution as we see as against this one. Never, 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 never. And of course, it's challenging, and of course, is it's not easy, and indeed, these aggressive actions and measures, arrest warrants, including against me and against Piotr, for example, but other colleagues as well, and also the sanctions that have been imposed, financial sanctions against 6 judges of this court, plus all the 3 prosecutors, are disheartening and create a significant problem. Is a punitive action against the judges for simply carrying out our duties. That's plainly what it is. It's unfortunate, but the question is, as you said, okay, are we afraid? Well, if we are afraid, then we are in the wrong profession. We cannot be afraid. Unfortunately, we don't have an opportunity for that. We don't like it, of course. It's not something that we accept. We're not looking forward to that, but we understand that unfortunately the world has moved into a new reality, and we need to deal with it. But be as it may, we still have a commitment and a duty to the values, best values of humanity. And we understand that's what the ICC was created for. And we were not created to, paraphrasing a former president, we are not here to deal with the easy things, but with the hard things. And we are dealing with them. It's not easy for us. It's not something we look forward to it either. But they are happening. That's what the organization was created to deal with, and that's what we are doing. And what can I say? We hear every day, we get news that more things are to come, that they are planning to shut us down, all sort of things. Well, I mean, we carry on with our job until the end. If they decide to shut us down, so be it. But the point that I made the other day, because I was in a Paris conference, also we have about 300 people in attendance. And the question was whether international criminal law was an ideal, and whether this ideal was coming to an end. And the fact of the matter is the international criminal law, or international criminal justice, better said, is not an ideal. It's here and it's felt. And the very reason why we are under attack is because it is felt. It exists. And I don't think that even if we were to find ourselves in the very unhappy situation in which we will not be able to operate as an international organization anymore, international criminal justice is still here and is a significant component of international law generally. And I don't think that is going anywhere. And it's not the end of the ideal. It's not an end of an utopia. And so with that, I'll leave my comment.
Thank you. Mr. President, we have a lot of questions on chat also. I've noticed that you have already answered 2 of them. But we will start with the question from Sama Anjum from Sri Lanka. I will read this. Thank you for sharing your insight today. In case where states like Sri Lanka have not acceded to the Rome Statute, but face increasing international pressure to ensure accountability, do you think the ICC's arrest warrant framework could evolve to address such accountability gaps more effectively? In other words, could the ICC adapt its rules or mechanisms in the future to ensure justice even when a country resists?
Thank you very much to Sama for her question. Sama, unfortunately, no, we cannot evolve ourselves to address alleged crimes that may have been committed in non-state parties. The only way in which we could gain jurisdiction or competence in order to address crimes that allegedly have been committed in non-state parties is by referrals of the UN Security Council. And as we know, it will be difficult in the current political landscape to get referrals to the ICC. That said, of course, it may well be the case that Sri Lanka one day says, you know what, we want to be part of the court, or they don't want to be part of the court, but accept the jurisdiction of the court. So, for example, in the case of Ukraine was not part of the court, but had accepted the jurisdiction of the court, and that's why we gain jurisdiction. And since I'm in the issue of Ukraine, even though I'm part of that situation, I just want to clarify this. And this happens with any state party or any state that have accepted the jurisdiction of the court. we don't act against non-state parties. It is not true that we exercise jurisdiction against non-state parties. This is not what we do. What we do is this. States fundamentally have the primary responsibility to address crimes, international crimes, in their own jurisdictions. So, in the case, let's say, of Sri Lanka, it is fundamentally the Sri Lankan criminal justice system that is charged to dealing with alleged criminality that may have taken place in Sri Lanka. And it doesn't matter who did it. If I, which I'm Costa Rican, if I go through Sri Lanka and I commit a crime in Sri Lanka, it doesn't matter that I'm Costa Rican. Sri Lanka justice will prosecute me because I have committed that crime in that territory. And this is on the basis of the principle of sovereignty, which is an international principle. Now, if a country where an international crime allegedly may have been committed is unable or unwilling to investigate and prosecute that case, that's when the ICC may activate its jurisdiction, and only in those circumstances. And it doesn't mean that we are acting just because we find it that we want to do it. No. We do it only because there are strong reasons to believe that that jurisdiction is unable to carry out the investigation and the prosecution of those crimes. Or, as the case is, the country itself have decided to refer to us the case. So we don't look exactly at who or what is the nationality of the person who allegedly have committed the crime. What we look at is whether a crime has been committed, what is the evidence of that crime in that territory, and we act upon that. It's not that we act against state parties, against non-state parties just because we are political. And I just want to clarify that point. We don't act in that sense.
Yes, thank you. Next question comes from Halina Kohan. Thank you very much for incredible presentation. Does the ICC have any mechanism to enforce arrest warrants when the state where the suspect is located is unwilling or afraid to make the arrest, such as in the case of ICC warrant against Vladimir Putin or Maria Lvova-Bielova? May the trial in absentia be applied? This is a question in partly you have answered in 3 ways so far, but if you would like to comment that, yes.
I'm afraid to Helena that I will, because of the specificity of the question, I cannot comment on that. So I hope that on the basis of what I explained already, you can gather, where the law is. But given the specificity of the question, I'm unable to answer. I'm sorry. Apologies for that.
Yes, of course, we understand this. The next question comes from Tandon Dita. In relation to confirmation of charges hearings, does the court ensure that the judicial bench appointed differs from the trial court judge in order to ensure procedural fairness and account for potential bias at the trial level?
Sorry, could you repeat that? I didn't grasp exactly.
Yeah, the essence of the question is somewhere between if there will be a different bench appointed for the trial that the judge, before deciding in the previous stages of the case, for the fairness of the trial.
Yes.
Potential bias.
Yeah, absolutely. You are right. So fundamentally, if a pretrial judge has already participated in a substantial manner in a case, that pretrial judge cannot sit on trial and cannot sit on the appeal either. So a different chamber generally is put together And for example, let's say, for argument's sake, that I am now in a case where I may have participated in a judicial decision at the trial, and then I go to appeals. I am barred from knowing any issues concern that the case of that specific individual. I might not be barred from knowing over other individuals, but if I am in the case, but if I have already ruled or participated over the case in one of the individuals, yeah, I cannot participate or I cannot sit in that appeal, for example, and I cannot sit on the trial either.
Thank you. And now a small relation for those that cannot read the comments. We had a question from Judge Peter Kovac. Dear Sergio, what is the reason that only a few ICC arrest warrants are on the Interpol red list? There are several ICC arrest warrants which are public and which are not from politically sensitive cases, but we cannot find them on the Interpol list. And Mr. President already answered shortly, and the answer is, dear Peter, fundamentally because warrants that may be filed secret and which existence is not made public. They are generally not communicated to Interpol. That was the answer. Would you like to add any comment or we go to next question?
Yeah. No, I see that Peter also asked about warrants who are public and that are not in the Interpol. So it's likely to be an issue with bureaucracy. Somehow it just have not been communicated. So
a very practical answer.
I don't know other reason to give to Peter. I have to assume that is the reason. I don't know of any other reason because there will not be any reason for it not to show. If they are known and the contents of the arrest warrant are public, then there should not be a problem to have them in Interpol.
Yes, thank you. We still have questions, Mr. President. And now I would like to ask Mr. Mohamed El Zaidi to ask his question.
Thank you, Judge Ugaldi, for the insightful presentation. And I have a question with respect to something you said during your intervention regarding the nature of the warrant of arrest and whether it is possible to appeal it. And as I understood from you, that warrants of arrest are not subjects to appeal. In the past, the court's practice was that a warrant of arrest would be issued by the judges, followed by a decision on the warrant. So theoretically speaking, we may say that we have a decision that maybe could fall within the parameters of Article 82(1)(d). That's an observation. If we look recently at what Israel have done on the 22nd of July, 2025, requesting the relevant pretrial chamber to vacate the warrant, wouldn't you think that this request, which the chamber later invited submissions from the parties, would amount to a decision to attack the warrant of arrest in itself, which you yourself said should not be subject to appeal? In other words, the core of the request of Israel is actually to say that this warrant should not have been issued from the start, which is the same idea to say, I'm appealing that warrant, but at a later stage. And the chamber, in that respect, responded by inviting submissions, the most recent of which was from the OTP. So I just want your observation on that in light of your initial comment.
Well, look, hard for me because this is an ongoing case, and it's difficult for me to make reference to any specific case. But I will say only this. The fact of the matter is that the appellability of decisions of pretrial chambers, it's somehow still a developing story, so to speak, because there are chambers who feel that unless the appellability of their decisions is listed in the statute, the decisions are not appealable. Okay, and so, for example, neither the warrants of arrest or confirmation decisions are listed as appealable decisions. There is something, of course, which in many circumstances had been used, which is to appeal decisions by requesting the leave of the chamber. That means that the interested party comes to the chamber itself and say, hey, you made a procedural mistake or procedural error, or you have made an error of law, and it is very grave because this affects fundamental rights, and therefore you have to allow your decision to go to appeal. So judges will look fundamentally at two things. First of all, if the decision is such that breaches very fundamental rights that will not otherwise be remedied at a later stage, they may be inclined to accept the appeal. But this is not settled practice. Now, the other way in which we've seen that there's been like a practice appears to have been created is to appeal decisions by going to one of the listed circumstances in the statute by which you can appeal directly without having the leave of the chamber. And this is what happens in a recent decision. I think there was issued either yesterday or one of these days. I think in Bangladesh, where there was a jurisdictional issue that can go directly to the appeals. They don't need the leave of the chamber, but by opening the door to the jurisdictional issue, then they attacked the issuance of the warrant of arrest. So this is something that is still developing, and we are trying to grapple, because as the case is, who gets to appeal and at what stage, and this is, as I said, a practice that is still developing. So this is all I can comment at this stage. Unfortunately, I will not be able to refer specifically to the case that had been mentioned.
Extremely interesting answer and a lot of information if we really carefully listen to you, as we do. We still have 3 questions, and if you allow me, I ask all of present, I will close the list because we are out of the time, and we have just one speaker who is still alive, but we really have to understand that he also has a right to rest, at least. So we will have 3 questions, and then we will close the discussion. First will be second chance for Mr. Abdirahman Elmi. Okay, would you like to ask a question? Because we can't hear you and we see something which is difficult to be defined, a red curtain probably. If I am not the only one who sees this red curtain. Okay, so we go to the next speaker. The second question, Zuzanna Bartnicka. Okay, if you have a short question, please.
Yes, I have a short question. So I wanted to ask the President Sergio Ugald again, and thank you for giving me the stage. So how does the International Criminal Court determine whether a given situation meets the legal thresholds for genocide, crimes against humanity, or war crimes, particularly when evidence may support multiple characterizations? Because I'm writing a paper on this, and I'm not really sure how to recognize when we're talking about the genocide, when we're talking about crimes against humanity. So I would really like you to talk some more about that. Thank you.
Well, thank you very much for your question. Look, fundamentally, we have, you know, that war crimes or crimes against humanity is just the heading. There are many different conducts that could be a crime, and there are also crimes that you could have, you know, either as a crime of a crime against humanity or a war crime, depending on the context. So it was called the contextual elements of the crime, the same as genocide. So, for example, you may have someone, or you may have a criminal act consistent of causing death, you know, multiple killings of several individuals, in the context that it can be classified as a war crime, but also as a crime against humanity, depending on the circumstances of how that crime may have been committed, and whether you have a kind of a circumstance where both contextual elements, I forgot the term, but lead to the same conduct qualifying as both. Okay, this is being intensely debated between the judges, because including myself, I have a little bit of problem sometimes, you know, in terms of saying that the same conduct qualifies as both, as a crime against humanity or as a war crime on the basis that are principles from which I am familiar with, which will preclude one. You know, you will always charge the one that is closest to the conduct. But there is practice in the court, and there is case law that allows for you to charge both and convict on both accounts. But fundamentally, at the end of the day, is about the contextual elements in which the crime may have been committed, and therefore you have to look first of all at elements of crimes, and we have, you know, a description of what the conduct you are looking at may be, in order to determine how you're going to charge it. And then, of course, you look at the case law as well. So, if there is no case law, then it is up to the judge to make an interpretation. So, let me give you an example. There is something called ecocide, which is completely new, and there's been a significant number of scholars saying that we have to charge ecocide as an international crime, for example, which is fundamentally the serious, significant damage to the environment, the environment. Okay, so it's not yet in the statute. It could become a crime, you know, but at the end of the day, it's something that a judge may have to interpret, you know, if there is not a jurisprudence on that. So that's what I don't know if I responded as much as you wanted, but that's all I can respond at this point.
So if I understand correctly, sometimes a person can be conducted for several crimes if they align, right?
Exactly. It's
Okay.
not, you don't have to.
You have to pick just one.
Exactly. No,
Okay.
I mean, if a person, let's say a person, let's say a person detain someone, torture him, you know, cause severe body damage, and then kill the person, you have three conducts there. And it doesn't mean that you need to pick up the most serious. All of the three are chargeable and punishable.
Okay, thank you so much. I really appreciate your answer.
Thank you. After this last question, we can assume that we will have a perfect paper from Madam Zuzanna Bartnicka.
Thank you. I'll do my best.
And now the last question from president to president. So President Piotr Hofmanski asks President Sergio Ugalde. Piotr.
Thank you. I just want to join the discussion about the appealability of the arrest warrants, especially after very interesting, in the context of the interesting question of Mohammed. So it's true that the statute does not provide the appeal against the arrest warrant, and sometimes for someone it could be strange in the context of the international standards of human rights. I could imagine that some judges would say, well, it's still appealable because it's provided for in the American Convention on Human Rights. But I don't think it's the case. But I don't know, why do you make this issue so complicated? I think it's easy. It's quite straightforward. You know, the arrest warrant cannot be appealed, but the arrested person can always ask to be released. And after the pretrial judge make a decision on this request, this decision is appealable. That is a very simple way to appeal the arrest warrant in fact. And it is what happened many times in the practice of the appeals chamber of the court. So I really do not understand why also the defense counsel are looking for the so complicated ways just to link the appeal to the arrest warrant, and the path, the legal path is quite simple, I think. So this was not a question; it was a comment. But I don't know. That's the end of the list. And let me once again to thank my friend Judge Ugalde for his time and for the participation in our webinar. Pavel, thank you also to you for fantastic leadership today. Thank you.
Thank you. But President Ugalde, maybe he would like to have a final comment. Would you like to have final comment? We noticed that you are still in the office. You're so brave for us. Thank you.
Well, thank you very much, Pavel, for your able direction of the discussion today. I won't duel with Piotr on this issue, because the one point I will point out to him is the very fact that, of course, the person have the opportunity to appeal. It means he has to be arrested in the first place, and that person doesn't want to be arrested. So that is the point here. But anyway, the point is, I want to thank you for the invitation to speak. As the case is, the court finds that it is important for us to engage and to explain ourselves. We are also public servants, and we need to explain our judicial decisions as much as we can. You know, we don't speak specifically about cases, as you would understand, but generally on the law, on how we see the law, how the law is evolving, we have an obligation to do that. And I thank, of course, the organizers and Piotr for the invitation to participate and to speak to you. I am very honored and humble to have done so. And I also take the opportunity to say thank you to Josh Tendafilova for participating, and for Peter, who I know is somewhere in the background, also for cheering up. Really appreciate it. Thank you again.
He is still here. I mean, Judge Peter Kovac watching us and joining us still. Mr. President Sergio Ugalde, what a perfect presentation. What a great discussion we had, thanks to you. We are very grateful for this meeting, almost 2 hours of the discussion about the arrest warrant. We could understand how this instrument works in practice, because you could speak about difficult issues in easy way. That's from my experience, the highest level of quality. So thank you very much for that. In the name of Dr. Ewa Hofmańska from Sunflower Foundation and Professor Piotr Hofmański from Krakow Center of International Criminal Law, we thank to everyone for being with us, for joining the meeting. We invite you for future meetings, and thanks again, Professor Sergio Ugalde, hero of this meeting, for being with us, and thank you for all we have learned from you. Have a nice evening. Please go home and rest a bit. And we also will remember, great that we will have this meeting recorded, so you can find this later. And please follow this information to others who couldn't join us today, that they could follow this discussion on the websites of both organizations. So President Ugalde and Professor Ugalde, thank you again, and thank you to everyone